I'm Dr. Berry, licensed psychologist, and here I share legal and entertainment news from a psychological perspective. If something sounds off, if I don't sound loud enough or anything, please let me know and I can make some adjustments. I appreciate you all being here. Today, we are going to hop right into Sarah Boone's motions hearings. So, if you've heard nothing about this case, I have videos linked below with all of the past coverage. I have until like 11:55 Eastern and I want to see how far things go. We are probably about maybe 10, 15 minutes behind court, and so let's go on ahead and listen to the prosecution entering they're discussing their motion to limit Sarah Boone's ability to present a self-defense claim based on her current version of events. That her current version of events does not meet criteria for self-defense. So let's hop right into this hearing. If you would like to listen with no interruptions, I have the video linked down below.
Is familiar with all those exhibits and has been able to review them prior to the hearing, so I'll just proceed to the legal argument.
You may proceed.
Your Honor, this is a motion to eliminate. We are asking for a pretrial ruling based on the proffered statements that the defendant has made, which should, in good faith and reliance, the state should be able to assume that that will be her testimony at trial, given that her latest version of events was just given to our expert last week. So we are asking for a pretrial ruling on if that is the evidence that comes in at trial, will she get a self-defense instruction? Will she be able to then open the door to all the things that come with self-defense, such as reputation evidence of the victim for being violent, which she may or may not be aware of, that's not required under the law, or prior instances of violence between she.
So they're panning over to Sarah right now, and Sarah has made request for water. She's made request for snacks, and we have not started our official bingo cards yet. I do think Sarah is going to make some type of request during the hearing, and her lawyer could be providing her with these things. It's not on the judge or the court system to make sure that she has those things, but it is what it is. She looks very nice. So her outfit yesterday, so she had like a green like blazer with a shirt under. She looked nice. That blue shirt with the puffy sleeves, to me that looked almost like her jail outfit. And yes, yes. We normally don't comment on fashion, but she's made a big deal on how she looks and how she presents to the jury. This is why we are talking about this.
In the victim or the victim in anybody that she is aware of, because that goes to the reasonableness of her perception of an imminent threat of death or great bodily harm. We are not asking to not be allowed to talk about these things during voir dire. The defense cited numerous cases and spent some of their time in their response about the ability to voir dire that. That was not the purpose of our motion. I don't think we mentioned voir dire because we understand that the defendant can, like any other witness, change her story again. So we understand that we both, on both sides, we intend on spending a great deal of time on it as well for the state of Florida. We need to explore these issues during jury selection. But what we are asking from the court now preliminarily is, if that is what the defendant is going to say in trial, and I'm not asking the court to make any credibility determinations about one version or another. We're asking you to treat this just like a C4 motion or a motion for summary judgment in a civil case. If this is what she says, does this amount to what they are asking for legally? And it's the state's position under the case law that no, because under her statements that she gave to the experts, there was no overt act taken by the decedent on that day. There was no overt action. And that's what's required under the law to trigger her response of acting in self-defense. There was nothing creating an imminent fear of death or great bodily harm. to her until she committed 2 forcible felonies and a non-forcible felony. What her testimony is we were having a good day. Now, what's different, and again, we're not asking you to make a credibility determination about what's different, but what is different than what you had heard at the motion to suppress is we were having a good day, but I'm on edge every day because of past instances of violence, including an instance the night before.
All right. So I just want to make sure that we're all on the same page. So with jury selection started on Monday, and they have a group of jurors that they're now going to interview one at a time. So the state's going to go first. I believe that starts this afternoon. That part is not streamed or televised. There are reporters that are reporting on it. Kathy Rousson, y'all know me in names, but there's a Kathy over on Twitter. She has been phenomenal. I think she's from Law and Crime. I've been following her. And then also Joe from Surviving the Survivor. I believe he's made it down a few days and has done some reporting too. The defense is then going tomorrow morning. They will start interviewing jurors individually because they each get 10 strikes, and they're going to try to narrow it down, I think, to 18 people. She only needs 6 on the jury, but the judge would like multiple alternates. Okay, let's keep going.
But we were having a good day. We're out on the porch. There's a dartboard out there. There's puzzles that we're doing. We're doing arts and crafts. We're doing everything to keep him preoccupied so he doesn't get sad or upset. Interjecting with some phone calls to his family, which she knows would potentially upset him, but that's her testimony. And then eventually it comes to a point in time where they're sitting on the couch and he reaches over to her and says, "Tag, you're it." And she apparently runs up to the shower.
Tag your it isn't hide and seek. Those are so the way we start hide and seek is, all right, you count to 10, you count to 20, count to 50, I'm going to go hide. That's how when I play hide and seek with my 7-year-old, that's how we've always played. It's never started as a game of tag. Now, what can happen is if you have multiple people playing hide and seek, once you find them, sometimes you try to tag them and that's the next person that has to count. But I've never heard hide and seek start with hiding, and the person that's tagged is normally the person that has to count and find the other person. I wonder if the rules of hide and seek are going to come into this. I really, really wonder. I am following the Ferris case. I think it's Farris. That is the case where a woman is charged with unaliving her husband. I believe that case is in Georgia. Recovery Addict is covering that one as well, and so please check out his coverage of that one. If they bring in any mental health experts or anything, I will definitely talk about it. I think she's blaming her son, that her son might have, like, I don't, her defense doesn't make any sense because it sounds like there's a lot of evidence against her. So that's a whole other case, but yes.
Shower to hide, and he apparently gets into the suitcase to hide, and it's not clear who's it. Eventually, she comes down out of the shower after she says she was getting cold up there and sees him in the suitcase and zips him up. And at the time that she zips the suitcase, what she describes as nearly entirely shut, but 2 fingertips could get out. Mind you, a 103-pound man, 2 fingertips. They're laughing. It's all fun and games still. There's still no overt act taken by the decedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm, of great bodily harm or death. And it's only when he begins to say, after she has zipped him up into the suitcase, and again, she is saying that she did not have malintent at that time. When he starts to say, "I cannot breathe," now she describes to the doctors that she does have bad intent, and she wants him to feel what she has felt in the past. She gets angry. is her description.
And I have never heard a normally there would be fear. Like normally you wouldn't get angry and that's the moment you decide to take your revenge in a self-defense and that type of case. Normally you are afraid for your life. Every self-defense case I've ever seen, every battered partner, spouse case I've ever seen, that's what's happened. That's what's been alleged.
She shakes the suitcase, she beats it, it falls over, it flips over. He sticks his fingertips out, she hits him with a bat. So she's now the initial aggressor, and we'll discuss jury instructions as we get closer. But she's the initial aggressor, and she has now committed forcible felonies, aggravated assault, and aggravated battery, stating that I only intended to keep him in there for a couple of minutes. I believed he could get out. She never perceived, according to her, that he would die or face great bodily harm.
No intent.
And she just goes upstairs knowing now he's mad because she won't let him out. Now, because of the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out. And she completely expects him to get out because her testimony is that he could get 2 fingertips out of the zipper. So, Your Honor, under the law, the state understands. We are deeply, deeply thoughtful about this request because of the risk of error. But this is just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is.
There's not.
And therefore, the jury should not hear about any prior instances of violence, any reputation evidence, any battered spouse syndrome, unless and until there is testimony that is self-defense that's recognized under the state of Florida's laws.
Yep.
So what we are asking for is a ruling that if, and this is a motion in limine, and a motion in limine is, hey, this is what's proffered to the court.
Does Owens look mad to me? Like he just kind of glanced over at Sarah. I'll go back just a little bit. Like, but she should have taken the deal. She should have, she really should have taken the deal. That's a whole other video. I've already done that video. If you're new to my channel, welcome. That was the last video that I did talking about her rejecting the plea deal.
This is a motion in limine, and a motion in limine is, hey, this is what's proffered to the court prior to trial. If this is what comes in at trial, this is the court's preliminary ruling, unless something changes. What we're asking for is a preliminary ruling that if that is what her testimony is, then we should not be allowing introduction of past instances of violence, reputation for violence.
So whatever that sound is, that's on law and crime side. Okay. So whatever that whooshing sound, okay. So I'm not, that's not on my end.
Go ahead, sir.
For battered spouse syndrome evidence. And furthermore, what the case law supports is our request that clearly this evidence can only come from her. There was nobody else in the apartment or townhouse that night. So she should have to testify before any of those things come in. And her testimony should meet the requirements of an overt act before any of this testimony comes in. It should not be allowed to come in prior to her testimony. And under the case law that the state cited, it's not unfair.
It wasn't me, though.
It's not forcing her to testify. She chose to raise battered spouse syndrome. The state completely understands we have the burden of disproving self-defense beyond a reasonable doubt. But what the case law says is we shouldn't have to combat this. We can't put the toothpaste back in the tube.
She literally went to sleep. And so I got confused in the if I die, I die. Like I didn't realize, I think she said that. I think in her interview with the state's expert, she probably said, I went upstairs, I went to sleep, and if I die, I die. Like she's I don't know. Like that's not what self-defense is. Because to me, that would mean that you're in what? Like it doesn't make any sense. And I don't even know if she made it upstairs. I don't know that she made it up to the bed to go to sleep. I wish they had pictures of that. Like, did she pass out downstairs? Did she make it upstairs? I don't know.
Until she actually puts forth the self-defense that justifies all this. So that is our request. We're not making any requests about voir dire because we understand she can come in and testify differently yet again at trial. And that's a discussion we'll have to have as well about how that will occur. The state's position is that if she changes her testimony yet again, she should have to give a narrative testimony. No attorney should be allowed to participate in
Yes.
putting forth new testimony about the events of
I love that statement that, hey, if she's going to change her story again, she should have to give narrative testimony because so that the lawyer isn't suborning perjury. And I wonder if Owens kind of likes that idea. Like, because if she changes her story again, it's probably going to be a lie. Because now she knows, oh, you didn't go far enough. You didn't say enough for this to meet criteria. So if she changes her story again, she should just have to get up there and talk, like Robert Tellis.
February 23rd. Thank you.
All right, thank you very much. Response.
Hmm. We're taking a minute to get up there.
Good
Oh,
morning, Judge.
Morning, sir.
I'm a little confused, but I want to make sure, so probably.
I gotta make myself. He starts with, "I'm a little confused," and me. Okay, I'm gonna let him talk. I'm gonna let him talk.
We can save some time here. My understanding is what the state's saying at this time, that there's no objection to raising this in voir dire to see how the jury would react or their feelings about it. So that's not it.
Wait a minute, but voir dire is outside of the presence of jury to see if it meets criteria, if it's legal to come into to be before the jury. I'm not a lawyer, but I know that much.
So what that leaves me is, I guess the
Co-counsel.
state's trying to say
Co-counsel.
there should be no mention of battered spouse or anything like that in opening statement.
That wasn't my takeaway either. My takeaway from the motion and the state's argument today is from a evidence perspective, concepts or testimony or even opinion evidence about battered spouse syndrome cannot be raised, including any of the reputation or specific instances of conduct that are contemplated by self-defense until there's a factual basis for it. My understanding of the defense's Dr. Harper's deposition is that the basis of her opinion, and please correct me if I am wrong, but my understanding is that the basis of Dr. Harper's deposition is based on her 4 or 5 interviews or sessions with Ms. Boone as to what transpired on the day and night in question. Is that accurate?
Did he understand the question?
Conferred.
Sure.
Okay. He doesn't have his Florida State mug today. Judge, I made your coffee be warm, but like the perfect temperature, whatever temperature you like to drink your coffee. Your pillow always be cool.
Judge, if I could have you repeat that question.
Sure. So my understanding,
funny.
well, let me ask, I'll have a more of an open-ended question. What is the basis factually
For self-defense.
of Dr. Harper's opinion? So if we were at trial right now for the purposes of this exercise, and you were going to call Dr. Harper to testify, what is the factual basis component under 90.702 in order to get her to testify? We're not dealing with her CV, her credentials. I'm not sure the state's going to have any position with regard to those, but let's just assume the state has no objection with regard to her credentials and that she is in fact an expert based on her knowledge, training, and experience in her field. What is step 1 under 90.702 to allow her to testify? What is the sufficient factual basis of her opinion?
Judge, I think her opinion would be based on several different things. Mainly, one of the things that her opinion.
So I think I have not watched this. I do not know what he's about to say. I think I think the expert is going to say because of past instances of violence that she was in fear for her life, but her actions don't match being in fear for your life. Like if yes, if he was in the suitcase and she was worried about what he might do to her, that you would call the police, you would leave the apartment, you would go to Brian's, like you would do something, but she went to sleep and she was clearly drunk. She antagonized him in that video and said, "This is for all that you've done to me." That that doesn't sound like self-defense to me, but that's I'm not a lawyer.
Would be based on is her interaction over the course of time with our client, Ms. Boone. That's one. Dr. Harper has also reviewed other evidence in this case that helps her form the basis of her.
So I do believe that George and Sarah had a toxic relationship. I do believe things would escalate to the point that he would put his hands on her. And I do not believe that anyone has the right to put their hands on anyone else. I also believe that she put her hands on him too. According to Brian's testimony or Brian's interview, not testimony because that hasn't started yet, her ex husband, when she would drink, she would sometimes get aggressive with him. And he would have, but he was bigger. Like he was able to kind of like, yeah, like he was able to keep her off of him. George was 5'2", 103 pounds, and I don't know what he had to do to keep her off of him. And I do think they had an issue together. And so this does not I'm not saying that I don't believe that she didn't experience difficult times. I do believe she likely experienced trauma in her life, but this situation does not sound like self-defense to me. I'm not the jury, I'm not a lawyer.
Opinion, and also her knowledge of battered spouse syndrome.
Same.
That has to be taken into account because, quite frankly, Judge, people who suffer for things from certain things, they don't know. That's why you have to, like, if you have to get an expert opinion as to someone's mental health situation. I mean, a person doesn't really know that they're suffering from a mental health problem. They have no idea in a lot of circumstances. What they do is they get evaluated by a doctor. The doctor has experience of what signs to look for in these things, and getting those signs with what they told and outside sources too. They are able to make a determination based on their training and experience. So,
But based on the Akendo case, which is cited by the state as to what battered spouse is it's an ambit of self-defense. So under the statute, are you traveling under 776.012 as your basis for self-defense?
yes, but this is the problem that I'm having here.
Okay.
Self-defense is a defense, it's an affirmative defense that's available to anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions. So my question really is, what's the overt act by the victim which would have given rise to self-defense? Because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
What is it?
Judge, the overt act has to come from testimony, and I agree in this case, but that has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you on that. I completely agree with you on that. And the case law is clear that if even there's a scintilla of evidence, I have to give that instruction. But we're not dealing with the jury instruction right now. What I'm dealing with right now is pretrial. The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue.
She definitely is.
How can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
If you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work, because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present evidence of self-defense, has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was told by Ms. Boone, or what questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited and the doctor answers. But that's not what this has to be based on. What it has to be based on is, what does Ms. Boone, in this case, testifies to on the stand? And if
So then what should happen, because if she's going to testify different than how she testified, or how she like what she reported to the state's expert, Dr. Werner, I want to say. Y'all know me in names. I want to say it's Dr. Werner, but no promises. So if she's going to testify different than that, then she should have to give a narrative testimony. And y'all should not mention self-defense or anything about the victim in your opening until Sarah Boone gets on the stand and finally provides a justifiable reason for self-defense, because she hasn't given one yet. This doesn't seem that hard. I don't this just doesn't seem hard.
any of that, excuse me, if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given.
Okay.
That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand. Now, any of the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made, or a decision cannot be made, until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
No, I don't think it is.
Any other arguments, sir?
No other argument.
Thank you. Rebuttal.
This is procedurally correct. Parties are allowed to get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there. But the court has before it the statements that Sarah Boone made when directly asked, what happened that day? What happened next? And there was no overt act
None.
taken by the decedent on that particular day.
I think and even Sarah's act, because she's still saying that she didn't mean for him to die, that she thought he could get out. So she's not even saying that she intended, like she's keeping the not intentional. And so what she's saying is that she intentionally didn't let him out because she was afraid for her life, but she thought he could get out on his own and she went to sleep. And if I die, I die. That's not self-defense, in my personal opinion, not a lawyer.
What they want to do and what is not permissible under the case law that I've cited, in particular, the one that says you get a threatening text and then 2 days later, you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog and that bad dog bites and that bad dog is bitten in the past, but on this particular day,
The dog isn't
the
doing
dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay, and you put the dog in the suitcase, and then the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up. That triggers you to, I remember.
I wish he wasn't making this. I wish he'd use like some other analogy, because he's now talking about George like George was a human. George was a person. George was a father. He was a brother. He was a son. I heard Tanika. Sorry, yeah, I'm bad with names. Y'all know me in names. Tanika's 2 cents. I saw her video this morning. Like, it's just so important to remember that. So I don't love that he's doing this, but I get it, I
When the
guess.
dog bit me in the past. You can't, that's not how this works. That's not how self-defense works with or without battered spouse syndrome. There has to be an overt act. You can't bootstrap
Hey,
and make
Jules.
up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And the state is asking, unless they are saying that the testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know based on the court's ruling what your client has already said to Doctors Werner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply, and all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either. Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams Rule victim and ask the court to rule prior to trial, hey, if this is how the Williams Rule victim testifies, and it's clear and convincing and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is.
I think the judge understands this. I wish he wasn't being so long-winded with this, because I get it. I think the judge gets it.
Second-degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements.
It's not there.
So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
I agree.
Thank you.
All right, thank you.
Just can I respond?
Briefly.
Normally not. Normally not.
Judge, it is not the responsibility of the defense to present their case at a pretrial.
I thought with self-defense, it is on the defense to prove it's self-defense. I'm not a lawyer, but like I could have sworn I heard a lawyer say that. Like,
Hearing. However,
But the problem is in the state's argument, in the case law, which the case law has been presented by the defense in your filings are not germane to the issue. We're not addressing jury selection and the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. And the state's argument is that due to the lack of an overt act,
Yes.
based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are Jorge Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
Yeah.
And then the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
It's not, Judge, but I find myself in the position now to disclose what our view of the overt act is.
Sure.
That's what this is what this motion has put us into.
But this is what they should have had to do already. Like, they're making it sound like their surprise is being ruined when this is literally what they were already supposed to do. They can't blindside the prosecution with this. They can't. They just can't. Like I think it's Kaylee. Like Kaylee said, let's hear it.
So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition as to the reaction of Ms. Boone by the overt act. And the overt act, I have to tell you, his hand is coming out of the suitcase.
She hit him with the bat.
That means he's about to get out of the suitcase. Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase.
But sir, she did not intend for him to die. Like, I'm still not understanding. We're going to hear it.
It's followed up by physical evidence because there's a picture provided of Mr. Torres's hand that shows a mark on that hand that it matches up with the bat. That's the overt act. It's like a gun, okay?
Not really.
You don't have to wait for them to pull the trigger. You don't. And it's based on all the evidence in the case, just not testimony, but also physical evidence that might support the testimony.
Might? He said might.
Thank you, sir. All right, the court has had the opportunity to review the motions, review all the case law. The state's motion is going to be granted in part and denied in part.
Okay.
With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings as to the concept of argument, again, there's no outright evidence of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279. No argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110. Rudin, R-U-D-I-N v. State, 182 Southern 3rd, 724. State v. Woodson, 349 Southern 3rd, 510. And Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd, 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records is relied upon in Roberts v. State by the 6th ECA in May of 2023 WL 3262633 at Pinpoint Site 2.
Making a record.
So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it, the court's going to rely on Ladd and Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in Ladd 564 Southern 2nd 587 has.
That is not good for her case, because in the opening, the defense is not going to be able to say what their defense is until Sarah gets on the stand, and they'll probably have to kick the jury out. I don't know. Like, I don't know what's going to happen. I think this is going to be difficult.
Has been established. Any questions with regard to the state's ruling? I'm sorry, the court's ruling, forgive me.
So there's a small chance that opening statements might happen tomorrow afternoon. So the state is we still don't have a jury seated. So there are 50 jurors, I think. I think they're coming back today. Or there's a certain number. I don't know how many. There are jurors that made it through the first part of the process of, do you recognize this person? Have you heard about the case? Have you seen the video? So the judge has already asked those questions, and some people have been weaned out for hardship or for those reasons. And now the state this afternoon is going to go through the jurors, and then they get to strike 10. And then the defense is going to go through the jurors tomorrow morning. That's my understanding of where we are right now. Okay. Okay.
Defense.
Meaning,
You want to mention an opening? You can mention an opening. Certainly, I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire. And even if the state objected to it, I most likely would overrule it based on the litany of case law.
Okay, so I'm going to pause it because I think he just said that they can mention it in opening. Okay, which is that's good for the defense. We'll see.
Defense.
meaning,
You want to mention an opening? You can mention an opening.
Okay.
Certainly, I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire. And even if the state objected to it, I most likely would overrule it based on the litany of case law.
So, but I think there will have to be enough evidence in order for that to be a jury instruction. So right now, because there's law about battered spouse. Okay. So they might be able to mention it in opening, which is a win for the defense.
That you cited, that you're allowed to dive into those things during jury selection. As to should the defense put on a case, the predicate under Ladd needs to be established before any expert opines to battered spouse.
my concern is opening. Can it be mentioned in?
Yes, that's your decision. That is your decision if you want to mention an opening. There's no preclusion from you doing that. Okay. Any other questions with regard to the court's order on that matter? State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you. Moving now to the defendant's motion in limine filed October 6th and the state's response to same. It looks like we've reached some level of common ground with regard to that motion. The court is going to grant the motion with regard to the
So what they're talking about now is the defense filed for parts of the interrogation to be kept out. And the state responded and they agreed. So there was a portion about bathroom. There was a weird portion about it really wasn't relevant. And so the state agreed, sure, we can cut that part. And then the defense also wanted the portion where the detective says, not intentional, that's not, he said something to the effect of, that's still a crime almost. Those aren't the exact words. And the state said the judge should just give an instruction that says, you are going to hear the detectives make some statements. Those statements are not law. It's like they're giving their opinion, like they're stating I think I don't know, but there's a ruling for it. I covered it in the last video. Let's listen.
Statements on page 69 through 71 of the transcript of the February 25, 2020 interview between Detectives Lowen and Kopsel and Miss Boone from page 69, line 6 through page 71. That will be granted to the state, not objecting to same. That leaves us to the statements on page 53, line 11, 53, line 13, line 14, page 55, line 24, page 56, line 1, and page 92, line 15. With that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all of y'all's case law. Okay.
The rule of sequestration applies to testimony of other witnesses, not to anything else.
Response?
Not from the state.
So I guess there's somebody there and okay, so I guess there's somebody there. Maybe one of the detectives are there or something.
I said there's no state witnesses.
So that's a no.
Oh, the prosecution is so over this. Good gosh. There was some serious tension right there. I, uh, oh my gosh. Because I think that's Detective Kopsel is sitting in the corner, I think.
May proceed with any argument, Mr. Owens. Yes, sir.
I'm gonna fast forward.
Thank you, Counselor.
Judge, the problem is the state attorney, when they filed the response, they didn't include the highlighted portion that's italicized at the beginning. Police opinions and statements regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted,
I personally think it should stay, but that's just me.
the trial judge must, upon request, give the following limiting instruction immediately before the recorded interview is played for the jury. That section, which is comments directed to the court, was not placed, to my understanding, in their response.
I thought it was. I thought I saw it, but maybe I didn't.
Okay.
She is super pretty.
Any other argument?
Judge, this was a 2-hour interrogation that occurred the day or two after the event.
No.
And the day prior to this time, or that morning, the detectives uncovered the 2 videotapes, the 2-minute video that Sarah Boone had recorded, and then followed up 11 minutes later with a 22-second video that she recorded and they found on her phone, which I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder.
Okay.
They spent 2 hours trying to do that
Okay.
any which way they possibly could. And the law says that they're allowed to use, and I cited several cases, cited the Smith v. State case, the ODEH, O-D-E-H v. State case, and the Eugene v. State. And in those cases,
I didn't see a citation to Eugene. I mean, Eugene's included.
So Jenny, this is today. Am I about 20 minutes behind live court? So this is live court. I think I'm about 20 minutes behind.
in ODA, but I don't.
Eugene is found, do you need the site?
I have it. It's included in ODA, but you did not cite it in your motion.
Okay. Eugene is 53 Southern 3rd, 1104. But law enforcement,
I'm going to speed him up to 1.25. Let's go. If it's too fast, I'll slow it down.
are entitled to use a variety of interrogation techniques to try to elicit a confession to the crime.
Okay.
But as in that case, in spite of the detective's efforts, Sarah Boone refused to admit that she was guilty of the murder. But as
Okay.
a last resort, Judge, and it was a 2-hour interrogation, it was the last portion, at least the last quarter, it may have been less than that, is when the detectives made some statements that are highly prejudicial to the defendant and tend to be opinion and tend to invade the province of the jury. And that's why this special jury instruction 2.8, recorded interview, effective law enforcement statements on the defendant, has that italicized portion in there. And the statements we're referring to under my motion, the second section of evidence to be excluded, page 53, line 11, well, he's dead as a result of your actions.
True.
And then paragraph 9, line 13.
She wouldn't let him out the suitcase.
He's dead as a result of your actions. She responded, line 14, I understand that. And then paragraph 11, page 55, line 24, I have one last question.
But she's claiming self-defense. Like, if she's claiming, I'm so confused.
I mean, you realize you're the person that killed him, right? Sarah Boone responds on page 56. I thought about that. And then lastly, on page 92,
Not funny.
well, intention or not, here's the detective distinguishing how he interprets the law and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolves you from everything.
She does.
That is exactly the kind of opinion testimony from law enforcement that the courts are worried about. The probative value of that type of opinion testimony about.
But that's what she said repeatedly in the interview. Like, she said repeatedly, it was not intentional. It was not intentional. It was not intentional. Like, she kept saying it was not intentionally. Like, she kept saying that. And so, okay.
About her guilt is outweighed by the prejudicial effect. Thank you.
Response.
I'm glad that was short.
State stands by the case law that we cited and that the jury instruction that would be read. I didn't feel it necessary to include italicized portions of comments to the court because this is what would get read to the jury. Those statements are designed to get responses from her. They did get responses from her.
Let me ask this question first, Mr. J. Do you disagree with counsel's representation of what is reflected in the Q&A at that point in time?
That's what was said.
To the extent that he is making the argument that they're expressing an opinion about
No. The words, not his opinion, not his thoughts or what it means, but the black and white verbiage is reflected in the motion. Is that what's reflected in the recording?
Yes.
I'm accepting that he would not misrepresent that to the court.
Okay, thank you. You may continue.
And as far as the last line on page 92, line 15, if something's designed to get a response that a normal person would respond to and there's no response, that still makes it a relevant statement.
That a normal person. There's so much side shade. Oh my gosh.
He's not giving an opinion on the law. He's giving an opinion about her reactions to this interview and trying to get a reaction from her when she says, well, intention or not, Jorge is dead. You act like when you say unintentionally, that absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview. So we defer to whatever the court's ruling is.
Okay, thank you. Any rebuttal?
Please no.
Just for the state attorney not to put that in there, the italicized portion where
I don't think it
the
matters.
court is giving instructions to the court with those comments. For them not to put that in there.
What about you not citing law, sir? Okay.
The Jackson case speaks for itself, and the court has reviewed it.
Thank you.
All right, thank you both for your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response, that the only issue is battered spouse.
There are so many worse things said in that interview. It'll be okay. Those statements getting thrown out, that's okay. There were much worse things that Sarah said in that. She said we were having a good day. We haven't had an incident in a while. There were so many other things that hurt her defense, in my opinion. Okay. The judge is fair. The judge really is fair, I think.
The issue is one of the elements is cause. And those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion as under the Bush case cited by the state law enforcement.
Wait a minute. Wait a minute. I think I misheard that. I thought they were, I thought he was, maybe he'll clarify because I thought he was saying he was granting the defense motion. So yeah, me and he's listening. So let's go back.
Jackson's case speaks for itself. The court has reviewed it. Thank you. All right. Thank you both for your motion, your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response that the only issue is battered spouse. The issue is one of the elements is cause. And those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion.
I think he meant defense. I think he just misspoke. Y'all know I misspeak all the time.
As under the Bush case cited by the state law enforcement's opinions are inadmissible due to the prejudicial effect that they may have. And I do find that this is the expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted and those will need to be redacted from. I apologize. Thank you. The defense's motion is granted for those reasons. Any questions or clarifications with regard to the court's rule?
So, I mean, if Sarah had never, I don't know, so sometimes Sarah comes off reasonable. Does that make sense? I don't think she's going to be explosive. I don't think she's going to do anything big. I don't think it's going to be Aliyah Boulaban or even Tellis ridiculousness. She's too controlled to let herself lose control like that. She just is.
Ruling state. Questions or
Very
clarifications
pleased.
with regards to the court's ruling? Questions or clarifications with regard?
Anytime she gets a win, she always, she loves rubbing it in, or I don't know. She likes gloating in it, in my opinion.
Part of the state's ruling, or the court's ruling, excuse me. All right, that takes us now to the
Morning.
state's objection and motion in limine to exclude decedents' medical records. I've reviewed that as well. State, you may proceed.
Okay, so I did not cover this one. So the defense has submitted 550 pages of George's medical records. And some of this includes, I guess there might have been some type of physical altercation with somebody else where he needed facial reconstruction, he needed surgery twice. They're trying to enter all of these pages, and the state wants to limit how much of that gets entered into evidence because they don't want to bury the jury in all of these, in this mountain of, paperwork that might be unnecessary for this. We're still at 1.25.
Just the other night, I received 550 pages of medical records regarding the treatment of Mr. Torres from two incidents, one in 2017 and one in 2018. The third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I've not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided. One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct?
Yes. And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence that she was aware of by the decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to weigh and consider. Not every page of these 57 pages is relevant. What is relevant is, yes, he came in for treatment, that narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive and it's going to be confusing. They don't need to read 57 pages of all of his treatment. The second batch was 487 pages regarding an incident on Christmas of 2017, when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. being a victim of violence is
Oh,
not
well,
relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering, and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that he, the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident. But this incident, it's irrelevant that he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in. I don't know that the 487 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened. And I don't know that it's relevant what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience that are in these medical records. It's unnecessary and it's prejudicial. Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Judge, as you know, we got on this case about 45 days ago, and I can't tell you how many pages
That's
I
on.
discovered
We
during
haven't
this that we
started the
had to go
cards
through.
yet. We
2 or
haven't
3 weeks
started them yet.
ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications.
That was
which are
probably
kinda like,
relevant.
emails or text messages.
It's probably relevant.
And that hasn't been narrowed down, but that was given to us. So that's something else we had to stop and go through over 500 pages. And they haven't narrowed it down to which ones they believe.
Are you saying that you gave them a bunch of discovery to like drown them in discovery because they drowned you in discovery? I don't think that. I don't know. Like, I'm a non-lawyer just listening to this.
Or incriminating to her. Okay.
Understood. But respectfully, that's not the issue before the
I
court right
understand
now.
that.
Not
But
at all.
Yes, the medical records are going to be narrowed down. And yes, we would have to make some tie to Sarah Boone's testimony to whether or not their medical records of the decedent, Jorge Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up. But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down. Did y'all not have Jorge Torres' medical records prior to me sending them to you? All right, well, we took the deposition of Dr. Harper, and as you know, Judge, these forensics.
So the defense and the state said, I think the defense has had these records since 2022. This incident happened in 2020. And Sarah, this is lawyer number 9, like this team of lawyers, because I think there's at least one co-counsel. There might be 2 additional, there might be 2. I'm not sure. It's Owens and at least 1 or 2 other people. And the defense has had these medical records and they have never provided them to the state. Never.
Psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client. But a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on Jorge Torres' medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that, but they were well aware that that's one thing that she relied upon. A lot of that collateral evidence doesn't come into, and it's going to be.
I need to jump into the breach here. I understand all of that. I understand that there's been volumes of documents that have been provided.
So just so y'all know, I love Judge K. Judge Kranick, like, and gave him a good pause too. Like, he's just like, wait a minute, I need to jump in because this is about to go way left. Okay.
between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument. And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boone's testimony.
You are the proponent of the evidence. So you have to establish relevance.
I agree.
And you have to establish that is not so substantially unfairly prejudicial.
I think the judge is telling Owens, you are the lawyer, not Sarah. Like, you are the one that has to make this decision. You can't give this to Sarah. I'm sorry. I mean it, every word.
Yes.
That the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40 some odd pages, I think the state identified as that. What of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down? Since
Well,
we have some level of common ground here.
He doesn't
My case
know.
is not going to be presented, I would assume, until next week. So I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay. I can't let you know today, Judge. I'll narrow it down, or we'll talk in the next couple of days.
Well,
by
the state's
Friday.
position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there.
Sure.
But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures. I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure there. I'm relying on counsel's representation.
I don't know. I'd have to look at them, but in one of the medical records, Jorge Torres was over a 0.31 BAC. Every time.
In 2018?
2018.
I'm talking about the 2018 incident with regard to the plate
I
glass
have to look at
window.
the records, but there is other evidence in those records that's going to be relevant after she testifies. That's when she gets beaten, when he gets really drunk. Or that's when he does.
But I personally think they get drunk together. I don't think he gets drunk on his own. I personally don't believe that. I wish they had gotten her BAC then the next morning. We don't have that.
something violent or threatens to do something violent when he gets really drunk. In one of those incidences, he was over a 0.3. When he gets over a 0.2 to 0.3, that's when he gets angry. He's fine up until that point. We're going to establish that. I don't want to put on my defense today, but Judge, there is going to be relevance to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
Okay, what about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. You know, it's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction,
What does that have to do with it?
surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
It's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find based on that whether or not that's relevant and probative to the case.
That's not how motions in limine work.
I think Owens does not want to upset Sarah. This is my own personal thing. I think Owens, if he had a different defendant, he would probably work differently. I think he does not want to upset Sarah. I think Sarah wants those records in. I think Sarah is telling, I don't know this for sure, okay? I'm just talking off the top of my head because in my personal opinion, I feel that she has a bit, I'm just going to say, so this is my personal opinion. I feel like she has a puppet in Owens, like she's kind of pulling his strings and getting him to do what she wants to do, and no other lawyer would let her do that. Like it sounds like, because and then when he gets up there and he's not sure, I think he's not sure because he knows what Sarah wants, and he wants the judge to say no and him not have to tell Sarah, this is not relevant. Sarah, we can't put this in there. Like, I think he doesn't want to tell Sarah no. My own personal opinion. Because when you tell her no, I think she probably escalates and walks out of meetings and gets big mad, I think.
Work.
I don't know what else to tell you, Judge. She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
I'm struggling with understanding how I can understand BAC results. I can understand that based on Dr. Harper's deposition. I can understand the narrative as to why they were there. I don't know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24th, 2017? How is it relevant?
Some of those may not be, some of the records may be relevant, depending on Sarah Boone's testimony about how what happened to him was tied to what he did to her.
I don't believe that.
Okay. Anything else?
That's it.
Response?
The two parties' discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose anything that anybody knows or may reasonably be calculated to lead to relevant information to the defense. The defendant's obligation is to let us know what they're going to use in trial. So for them to come in today on the third day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is wrong. They got these records, and I understand that there's a ninth
2022.
set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021. And they just get disclosed to me overnight a couple of nights ago.
Yeah.
In their discovery responses, in the First Amendment, Second Amendment, third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Ms. Boone's box, apparently, that Billy Lane had acquired.
I don't think Sarah's happy. I think Sarah is pushing and saying stuff. I think, and poor Owens. I don't feel, but like, okay.
Years ago. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case, or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both, and the state too, we both disclosed what are we actually introducing.
Only when she's getting
The
her
state
way.
has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF from the thousands that it was, and handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here. We're not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some conversion, 10, 15% for legal blood, at the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window. On that date, again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's
When he
relevance
got
is. If
attacked.
we're all at a family gathering at the Torres's, and she says something that triggers one of his brothers to violently beat him nearly to death, what his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day, and that's just not my understanding of how the deposition's read. So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning. Thank you.
Thank you. All right. The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol content in both the December 24, 2017 incident and the 2018 incident, I find potential relevance. So I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records.
Did y'all see that smirk? Because I think she's thinking I can say something to get those records in.
Nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. I'm not foreclosing you, but there needs to be something for you to link these documents together for me. All right. Any clarification or questions with regard to the state's rule or the court's ruling? Defense. All right. Thank you. That now takes us to the objections to the evidence. Give me a moment. We have the defendant's objections to state's digital exhibits filed October 15th, the state's amended or states, excuse me, state's response to defendant's fifth amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are. It just identifies them. I'm not sure what it is that they are.
It's tracking their fifth amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list. It would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph 1A, and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item, tracking their fifth amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's third amended exhibit list. When was the fifth amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of some pleadings, but they're not bait stamped with the clerk of the court's e-filing system on the top left. So I'm not certain that they've filed anything with the clerk of the court.
Here's the other problem that I have. All I see on my end is the notice of providing. It doesn't identify anything. It's a one-page document. So it's hard for me to say what, I know you may have seen it, but the court hasn't seen it based on what's been filed.
I believe I would direct any questions about why that's not filed with the clerk of the court to the defense.
Okay. All right. I need clarification, Mr. Owens, as to when the fifth amended reciprocal discovery exhibit list was filed and what is in it. Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify.
I don't know that Sarah, because I've never seen, y'all correct me in the chat. I've never seen a defendant helping the lawyer find when they submitted things. I have never seen that. Never ever seen that. She's touching his iPad to like help him find these things. Oh my gosh. No. Like this is, oh my gosh.
Anything for me to line up item 1 and item 1 as to what they purport to be.
You're asking for when it was filed? We're checking on that. When it was filed. What was the next question?
All I have is a notice. So on September 27th, there was a notice of provision of defendant's third amended exhibit list. And it's just that. What we intend on utilizing has been provided. But I don't have anything else as to what those items are.
Okay. Did you want us to provide you with a copy of those to your JA?
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else and
Unless we've got some housekeeping matters to address for this afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second.
I'm gonna fast forward a little.
I got an email this morning from Juror Services, juror number 551. I don't recall from what panel. No, I'm sorry. Juror number 471, panel 3, seat 48. Tested positive for COVID, and Jury Services has instructed him not to return.
Yeah.
Juror number 551.
What was the first one?
Sure. Juror number 471, panel 3. That would have been yesterday morning, seat 48.
Dang. So whoever was at jury yesterday, they tested positive for COVID. Oh gosh. May everybody else in the jury pool, your immune system be so strong. Like, I feel like I want to say a prayer. Like, good gosh. Oh.
Advised Jury Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him because we don't need that floating around.
No.
The other juror, 551, I don't have any other information as to what panel or seat. She took a COVID test and was negative. She is planning on reporting today. So due to the shrinking from 54 to 53, jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor. The deputies have already brought in additional chairs so that we can fit 53 people in here.
Can we just have everybody wear a mask? But this is Florida, and I know they're not going to do that. Everybody should wear a mask. They were all exposed to COVID yesterday. Everybody should be wearing a mask, but they're not going to do that. if I was on the panel, I would want to be able to have the option to, and I'm not afraid of COVID, but like if I can wear a mask and have a little bit more protection, then I would just want to have that option.
That's the only other housekeeping matters that I have to address.
I thought
So
Florida.
are there any housekeeping matters to address from the state before we address the objections issues?
Is it wise to not utilize that expanded space when two of these panels, or at least one of these panels, has already been exposed to COVID?
Yes.
Would it not be wise to use the bigger space in 23 since one of our panels has already potentially been exposed to COVID, as opposed to packing everybody in?
So they're going to figure this part out.
To address jury selection location this afternoon, and to give the defense the opportunity to provide the
So they
the
took a
fifth amended
recess.
exhibit list. With regard to juror 55,
I'm
suit
back.
and white blouse from this morning,
So we just skipped ahead past the recess, okay? Because they're going to work things out of what they're going to do later this afternoon.
can y'all approach?
Okay, going to fast forward. Oh, we might catch up to live. Okay, maybe not. Oh no, another break? Okay. Live? Wait a minute. Live? Okay, so I think they're still on break. Excuse me. Sorry about that. Let me end that. So I have the link to Law and Crimes chat down in the description if y'all would like to continue there. I'm sure there are other people. So I saw Lori Reese was covering this. I'm sure there are multiple other people covering it as well. I do have a 12 p.m. client, and so I am not going to be able to continue to cover this part. I expect that the judge is going to have some questions about why the defense hasn't submitted their list to the court yet. And so they're going to have to work that out, and so those things will be happening later. My plan is to stream again, possibly like Friday's a busy day, so it'll probably be Saturday. Saturday will probably be my next stream unless I get a cancellation. So please make sure you're subscribed and the notifications are on. I did have a question from Priya. Do you think Sarah Boone's choices here are due to a complete lack of insight, immature ego defense, or stubborn refusal to accept responsibility? Yes. So I think Sarah only sees success in this case as her winning and being found not guilty. And she does not want to be viewed as a murderer. She does not want to be viewed as the person that caused his death. I think she desperately wants to hold on to the not intentional, which might get her down to manslaughter, but it doesn't mean not guilty, in my non legal opinion. This is going to be in the hands of the jury, and we will see. I do think both of those things could be true, that she could be stubborn, and she comes off emotionally immature to me. She comes off as a perpetual victim. And if you didn't catch Surviving the Survivor, Dr. G Explains was on Surviving the Survivor last night and talked about Sarah Boone. I was in the chat. I caught it late. Thank you to Karen, UK lawyer. She commented on one of my videos that Surviving the Survivor was live, and I went over to check out their stream. I think if she's found guilty, she is going to blame Owens. She is going to blame the court, the jury. She is not going to accept responsibility for it at all. She's not going to accept it at all. Dr. G Explains, if you have not heard of his channel, he is linked. If you go to my main page, like if you go to my YouTube, at the bottom, I have recommendations, and Dr. G Explains Of course, Emily D. Baker, Natalie Lawyer Chick. I have some of my favorite, I think I have the lawyer down there too. I have some of my favorite channels down there. Y'all will find me in the chat on like all of these channels because like y'all turned me into a true crime junkie. Like, why did y'all do that? And so I would like snacks too. Okay. So like today for work, like I have snacks, but I think Sarah believes it's other people's responsibility to take care of her. In the jail, she's been very demanding with the staff. Like she's been like and I think she thinks the judge works for her almost, and the judge is on her side almost, and that he's the one that she has to go to get some of these needs met, when it's really not. You don't go to the judge about snacks. Who does that? You ask your lawyer, you ask the jail staff, because it's my understanding that she sent over each day with a lunch, like a paper bag lunch and cookies. Like I think she sent with snacks, but I think she wants special snacks. And I think that's a part of the entitlement. And I don't blame her for asking. Okay. Like, okay. She asked because some of the things she asked for, she got. Because she has those flat shoes, like she got special shoes, and other defendants probably have to wear slippers or have to wear other things. Like some of the things she's asked for, she has actually got. And but I do think all of this will play in to down the road. If she's found guilty, I don't think the judge is going to have any mercy on her. I don't think the judge is going. Now, I think he's going to be fair, but I don't think he's going to think, "Oh, poor you. Like you deserve the minimum." If she's found guilty and the judge knows that she was offered the 15 years and she denied that manslaughter. If she's found guilty of second degree and she's earned life in prison, not quite earned, but you know what I mean? Like if that's if she is found guilty by the jury, we'll see what happens. I'm definitely going to cover this. I will be covering the expert testimony, her testimony, um a lot of I don't know how much of just the parts of the case that are just the state presenting their evidence. I really want to cover when she gets on the stand. Yep, the minimum is 22 and a half years. That's the minimum of what she's facing if she's found guilty. And that video, I personally cannot get past the video, and the jury is going to see that video. And if I was the prosecution, I would play that video, possibly if I was able to play something in my opening, if I was able to play it in my closing, and the jury would have to like that video, that would seal the deal for me personally. But all right. They are being so careful. SJ, Sheila, I agree. They are being so careful with this because they don't want to create an appellate issue. I don't think there's going to be an appellate issue if she is found guilty of this. And so, jury selection later today. I hope you all enjoy the rest of your day. Bye.